Hi, my name is Blair McClanahan, and I am an attorney and the managing partner at the law offices of Cheryl David here in Greensboro, North Carolina. We are an estate planning, probate, and elder law firm, and we focus primarily on those three areas. So while we can't help you with your traffic ticket, we sure can help you with your estate plan. We get a lot of clients in week to week, and one question I hear over and over again that I wanted to take time to address today is, what is the difference between a will and a power of attorney? So we're probably familiar with wills. We are giving directions on who assets, real estate, cars are distributed to at death and naming who we would like as our personal representative or executor. A will is a great tool for us to be intentional about who we leave assets to at death. And for those that pass away without a will, the state of North Carolina has a plan for you called intestacy. Assets may not go to who you think or would even want them to go to. Even if you have a spouse, they do not automatically inherit everything if you pass away without a will. So for that reason, if you're married, it's very important to have a will if it's your intent to leave everything to your spouse. And if you're not married, it's even all the more important to have a will so that we can direct who we leave our assets to and who is in control of making sure that happens when you pass away. Now, at death, your administrator or executor, two words that can be used interchangeably, have to file the will at the courthouse. Now, that's an issue that I get a lot of concerns about. I have to go through probate if I have a will? Yes, a will is a ticket to the courthouse. You are telling the court what you want to happen, and it's the court's job to make sure that it does, in fact, happen. This is a process called probate. We open up an estate, and it typically, for a full estate, for estates over $20,000, lasts a year. Now, for some of our clients, they're frankly not okay with this. They don't want their families going through the court. Maybe they've had bad experiences themselves. But regardless, they know that they don't want their family stepping foot in the courthouse. So for these clients, we often recommend something called a trust. A trust is a lot like a will, but in contract form. And just like you may have contracts with your painter that don't go through court, neither does this one. Now, a trust will still list a lot of items that you'll see in a will, such as who is the beneficiary, who is in charge, except instead of an executor, it's called a trustee. Now, while you're living, you are the trustee of a revocable trust. You have full control of your assets. There's really not a change day to day. This is more so a standby device to keep your family out of court when you pass away. This trust follows your social security number, and there's really not even a change with how taxes are filed. What we're really accomplishing with a trust is keeping the next generation out of court at your death. So in a nutshell, that is the main difference between a will and a trust. Both are really great options, and one hopefully makes more sense for your situation. Thanks so much for listening. Bye.